First speaker on my list is the distinguished permanent representative of Sri Lanka. I give the floor to the distinguished permanent representative of Sri Lanka.
Mr. Chairman, Sri Lanka aligns itself with the statement delivered by the distinguished representative of Iran on behalf of the non-aligned movement and makes the following comments in our national capacity. Mr. Chairman, Sri Lanka welcomes the continued focus on the rule of law at the national and international levels by the United Nations since the General Assembly's 61st session in 2006. The rule of law is a concept, as we know, that describes the supreme authority of the law over governmental action and individual behavior. It is a concept grounded upon the principles of democracy, limited government, and a rules-based order in consonance with the social contract as propounded as far back in the Leviathans. We appreciate that the United Nations Secretary General's report A/77/213, Strengthening and Coordinating United Nations Rule of Law Activities, which emphasizes the United Nations Rule of Law initiatives and advancement over the last year at the local and global levels, has been timely. Mr. Chairman, the rule of law, as I said, is a critical principle and the cornerstone of governance. It is essential for maintaining political stability, achieving global peace and security, and advancing economic and social conditions, as well as safeguarding individual liberties and rights. For all societies, both nationally and internationally, the rule of law establishes the fundamental framework. It is our shared responsibility as member states to strengthen it at the local, national, and global levels. We must also not forget that the rule of law is not only a standalone goal, but also a crucial enabler of other SDGs as we work towards realizing the 2030 agenda. Sri Lanka reiterates that the independent, effective, and competent judicial systems are the cornerstone of the rule of law, as they provide an appropriate peaceful means of resolving disputes, ensuring accountability, and providing justice. However, it must be appreciated that a proper balance between the three branches of government, the judiciary and the executive and the legislature, must always be maintained. Mr. Chairman, Sri Lanka welcomes the focus of today's debate on the subtopic, the impacts of the global coronavirus disease pandemic on the rule of law at the national and international levels. The COVID-19 pandemic has had a profound impact on governance globally. As countries grapple with the corona crisis, its implications for justice and the rule of law are becoming clearer. The pandemic created a host of new legal challenges. Just as more courts and legal aid services across the world were closing, reducing, or adjusting their operations, inevitably, the most vulnerable groups in society were suffering the harshest of consequences. As countries battle to contain COVID-19 and respond to the socio-economic impact of the crisis, they are reliant on justice providers to respond to a wide range of justice concerns. The administrative complexity, the slow pace, the high cost associated with statutory courts meant that in many settings they are unsuitable to deal with these pressures in a fair and effective way. We must therefore look to a broader range of pathways to respond to this crisis. Across a range of countries, customary and other non-statutory justice providers are widely used and to fill a gap due to the shortcomings of statutory legal systems. Alternative dispute resolution, traditional, tribal and community-based courts, and paralegals can all reduce the burden on statutory systems while potentially providing faster and more satisfactory processes and outcomes to users. These networks also have an important role to play in coordinating containment strategies, sharing health and other information with communities, and responding to rights violations by security services. Of course, these providers may themselves be guilty of rights violations and procedural unfairness. All justice systems reflect particular power dynamics. It is therefore critical, I say, that we understand the role of these systems in their wider political and economic context, Mr. Chairman, to ensure that a well-intentioned support does not have unintended consequences. The COVID-19 crisis has tragically reduced people's access to justice Just as their need for it rises, lockdowns have resulted in a surge of domestic violence, and the economic crisis is increasing over disputes over land, employment and debt. Women are particularly at risk. However, there are two beacons of hope. First, countries have shown that they are capable of rapid and radical policy responses. Many have quickly reduced prison populations and are experimenting with virtual courts. The recognition that century-old legal traditions can be reformed within months shows long called for reforms to engage in domestic violence, make greater use of grassroots legal defenders, and scale up innovative technological approaches as far as possible. Regional police forces have yielded few sustainable results. Mr. Chairman, Sri Lanka has therefore accommodated its diverse cultural, racial and religious differences within its legal system, reflecting its strong commitment to the rule of law. The Sri Lankan constitutional provisions on fundamental rights serve as an illustration of this reality. The protection of minority groups, the advancement of women's rights, the protection of children's rights have all benefited from the provisions of the Constitution. Additionally, minority rights are supported by a number of personal laws that are enforced by the legal system. Mr. Chairman, the General Assembly is entrusted with the crucial responsibility of promoting the steady advancement of international law and its codification under Article 13 of the Charter. The United Nations has been successful in significantly strengthening the rule of law on a global scale through multilateral treaty processes that have been developed over the years. Multilateral treaty bodies have grown in numbers dramatically over time. While this has contributed to advancement in international law, it has also heightened the need for states to enhance their capacities. Mr. Chairman, finally, we stress that the laws are only as effective as how they are implemented. Additionally, implementation is only as good as fairness it is based on. Sri Lanka therefore reiterates its call for systems to ensure a fair and just application of laws and principles agreed upon by member states of the United Nations, including the principles enshrined in the Charter of the United Nations, and having full respect for the rule of law. I thank you, Mr. Chairman.
I thank His Excellency, the Permanent Representative of Sri Lanka, for his important statement